On behalf of the Order of Malta, I would like to welcome all of you to our webinar on forced labor and transparency supply chains. In tonight's webinar, we will focus on the lack of effectiveness of self-regulatory mechanisms and the need for prescriptive mandatory approaches. I would first like to thank the authors of this report. We have two of them online, and the Aotearoa New Zealand government for their efforts to improve the implementation of the monitoring of supply chains. Today, more people are trapped in modern slavery than at any time in history. A staggering number of 50 million people were living in modern slavery in 2021, according to the ILO-IOM Work-Free Global Report, global estimates of modern slavery published in September 2022. Of these people, 28 million were in forced labor, with 1 in 8 being a child. More than 80% of the cases of forced labor can be found in the private sector. Hence, forced labor is present in practically all supply chains of the goods and services that we consume every day. Brian Islin, founder of the NGO Slave Free Trade, says that, quote, every day we touch slavery more often than our face, end of quote. The UK Modern Slavery Act of 2015 was established 7 years ago and was hailed as a pioneering landmark piece of legislation. However, the analysis of its results after 7 years are, while disappointing, very instructive and will allow the introduction of corrective measures by the international community. An example of an analysis of the present UK legislation, the Business and Human Rights Resource Centre report 2021, entitled Modern Slavery Act, 5 Years of Reporting Conclusions from Monitoring Corporate Disclosure, states the following, quote, the provisions of the UK Act itself, based on a requirement to submit a trifling level of reporting which has not been monitored or enforced, has failed to drive systemic corporate action to expunge forced labor, even in high-risk sectors. The Act has raised awareness of the prevalence of modern slavery and encouraged a cluster of leading companies and investors to do more. But ultimately, our analysis of 5 years' worth of statements in the Modern Slavery Registry has revealed no significant improvements in the vast majority of companies' policies, practice, or performance. Instead, lack of enforcement of the reporting requirement itself and lack of mandatory reporting criteria has led to dismal results. End of quote. In tonight's webinar, we will base our discussion on a recent expert report entitled An Opportunity for Impact Report, Recommendations for Regulating Modern Slavery in Supply Chains to the New Zealand Government, introduced by Dame Sara Thornton, DPA QBM, then UK's Independent Slavery Commissioners, which offers very clear recommendations to more efficiently enforce supply chain controls. This report, available online, modernslaveryrecommendations.nz, and in the handouts of this webinar. Dame Sara Thornton, in her introduction to this document, emphasized that, I quote, while modern slavery is perpetrated by criminals, human traffickers, and ruthless opportunists, it is enabled by lax governance, ignorance, aggressive commercial practices. While legislation is no silver bullet, it is the most powerful method of forcing greater corporate responsibility at scale. End of quote. The report underlines that a recent shift among international experts, instigated by the apparent lack of effectiveness with purely self-regulatory mechanisms, encourages the introduction of new legal mechanisms to go forward from a voluntary to prescriptive or mandatory approach. We are very honored and grateful to have three distinguished speakers for this webinar. First, Professor Dame Sara Thornton, UK's Independent Anti-Slavery Commissioner from May 2019 until April 2022, in succession to Kevin Hyland. She is Professor of Practice in Modern Slavery Policy, the Rights Lab, University of Nottingham. She is a retired British police officer who was the first chair of the National Police Chiefs Council, NPCC, and the former Chief Constable of Thames Valley Police and Vice President of the Association of Chief Police Officers, ACPO. Then, Rebecca Armstrong, one of the authors of the report, human rights practitioner with 14 years experience specializing in modern slavery, human rights, and humanitarian law. She is the Director of Business and Human Rights Consultants and Head of the Advocacy and Justice at World Vision. Rebecca is Chair of the New Zealand Human Rights Research Coalition, responsible for publishing the first research on worker exploitation in New Zealand. She is an advisory member of the New Zealand Centre for Research on Modern Slavery and a member of the Modern Slavery Leadership Advisory Group to the New Zealand government. And then the third speaker, Dr. Natalia Sablewska, another author report, lawyer and social scientist with 20 years experience spanning the public sector, governmental and non-governmental organizations, and academia in 5 countries. She is currently professor in law and society at the Open University in the United Kingdom and holds further academic affiliations in New Zealand, Australia, and Cambodia. Natalia specializes in public international law and human rights law with a particular focus on corporate-related human rights responsibilities. She is the chair of Australian Lawyers for Human Rights, Business and Human Rights Committee, and a member of the Modern Slavery Leadership Advisory Group to the New Zealand government. The first speaker, Professor Dame Sara Thornton, provided us with a powerful 9-minute video statement. We are all looking forward to watching it.
Hello, and I'm very sorry that I can't be with you this afternoon, but I'm at a conference with Finance Against Slavery and Trafficking in Cape Town, where we're really looking at what more could be done in the great continent of Africa. So I hope you have a good discussion. But I wanted to say a few comments about this report. I mean, the first thing to say is, of course, I wrote a foreword for it, so I very much welcome it and very pleased to write the foreword, but very pleased to comment on the report. And I think it's symptomatic of an international shift away from voluntarism to more regulation and more legislation. And it seems to me, whether you're talking about the United States of America, whether you're talking about Australia and New Zealand, whether you're talking about Europe, there is a general shift across to more regulation. I think a sense in which waiting for people to do the right thing voluntarily is just taking too long. And I think the other thing, before I talk about the particular recommendations, is the acknowledgement that it's really important that the United Nations guiding principles on business and human rights are a thread running right through this. So I do have a huge amount of sympathy for multinational companies if they're expected to comply with regimes that are very different in many different parts of the globe. And the more that we can help to develop more consistent standards and more consistent law, I think the better. So hopefully it's helpful, but I've read through the report and the recommendations, and I was just going to make some comments on each one of them. The first one, recommendation 1, where you're talking about the application to both private and public bodies, I think is really important. In the UK, our Modern Slavery Act, all the provisions around business under Section 54 just applied to the private sector. I think there's a general view now that that was a mistake, The government have acknowledged the need to extend the provisions to the public sector, and in the Queen's speech in May this year announced that they would do that. A recent example, which for me illustrates why this is so important. I was aware that Supermax, which is a company based in Malaysia, which manufactures rubber gloves, had last October, I think, a withhold release order, an import ban imposed by the United States. And then just a few weeks later, the same company were put on a procurement contract in the UK. Now, how can that be right? And I do think if it was the case in law that the provisions applied to the public sector, it would reduce the likelihood of that happening. The second recommendation is very much about transparency and transparency beyond Tier 1. We know there is very little transparency beyond Tier 1, beyond those contractual relationships. But I would also suggest that you need to think about transparency and disclosure. It's not just about being transparent with the company, it's how much do they actually disclose what's going on. Recommendation 3 is about mandating due diligence, both environmental and human rights due diligence. I'm still unclear about the benefits of mandating it in law, in as much as there is legislation in a couple of countries. The French example is the most obvious cited, and there is legislation now in other countries such as Germany. But it's such early days, and it's quite difficult to understand whether this really does protect the most vulnerable workers from exploitation. Because my view is that there is forced labour in most international supply chains. And what we should be doing is encouraging businesses to find it and address it. And the issue for me is the extent to which we have evidence that mandating due diligence helps us with that task. And I guess the bottom line, as I said, is, how clear are we that it benefits the exploited worker? Recommendation 4 talks about reporting mandating categories of information. Again, that's something which the United Kingdom government have in the Queen's speech said that they're going to move to that. I think that's right. Otherwise, you end up with tremendously variable quality of any statements and of any disclosure. And I think mandating what's reported can be very helpful. Linked to that is the proposal in recommendation 5 for a registry. Again, we have a registry in the UK, but it's not mandated for companies to upload their statements to the registry. The proposal in legislation is for that to happen, and I very much support that. Recommendation 6 is about the Anti-Slavery Commissioner, a subject close to my heart. I do think it's really important to have somebody who stands in a way outside government, but also outside a campaigning sector, and can use evidence and data to speak truth unto power. Couple of thoughts about reflecting on my own experience. The UK approach is a 3-year term. I suggest that 3 years isn't sufficiently long. I think 5 or 7 would be better, because you need to have confidence that you can speak the truth and you are not reliant on a government who you might be upsetting renewing your contract. So I think that's really important. And particularly in the UK at the moment, there is no commissioner being appointed, and we have a government that's making very concerning comments about alleged abuse of the Modern Slavery Act provisions, and there is nobody to stand up and say, well, actually, the truth is, the data says, the evidence is. So I think it's really, really important. You also suggest in recommendation 7 an advisory group. That seems really good to me. There's been a sort of advisory group, a sort of strategy group in the UK. Early days, ministers would chair and attend and took concerns seriously. Over recent years, I'm afraid that level of interest has declined substantially. And I think a real frustration from those in the strategy group as to whether their voices are being listened to, let alone heard or acted upon. Recommendation 8 about greater accountability. Whether it's fines or whether it's import bans, you need something that's going to grab the attention of the C-suite. So this is a top issue that is a material risk to a company, and therefore action needs to be taken. So I'm in favour of those sorts of recommendations you make. In terms of remedy and liability, I'm continually concerned about the very, very few occasions that companies ever provide remedy to workers who've been exploited. I guess the exception to that is the Malaysian rubber industry, where over $100 million in remedy has been paid by a variety of companies as a result of import bans. So I think remedy is something that we really need to look at. I also think that it's worth looking at proposals that were made in the UK for a duty to prevent forced labour, and with a defence that you've taken all reasonable due diligence steps. It's the sort of approach that we have to fraud, and I think it's worth looking at in terms of just tightening and upping the pressure on businesses to make the right decisions. And lastly, recommendation 10, and I was wondering whether you would ever get to this, but it's the suggestion that you should look at import bans. I think that the US deployment of import bans, both under the Tariff Act and into the Uyghur Forced Labour Protection Act, are proving to be extremely effective. I hosted a conference last week and we had Customs and Border Protection talking about their approach. We had an NGO talking about their contribution, and we had a business talking about the impact and the way in which the import ban, all the steps they'd had to take to have it removed, had really made a huge difference to the way the business operated, and most importantly, had significantly changed the experiences of the most vulnerable workers. So hopefully that's a useful run through the recommendations. I hope I haven't spoilt the next presentation if you were going to do that, and I wish you good discussions and good to be with you, if only on video. Thanks a lot. Bye-bye.
Well, thank you very much. Thank you very much for this very informative intervention. You know, you can download this video in the handouts and also on video, on Vimeo, excuse me, and it might be quite interesting to see that all over again. But now, the second speaker, an author of the report, is Rebecca Armstrong. Rebecca, thanks for being with us tonight, also early in the morning for you, because you're speaking from New Zealand. I'm so happy and grateful to give you the floor. Please.
Thank you. Ina mana, ina reo, ina karangataha maha. Tēnā koutou, tēnā koutou, tēnā koutou katoa. All authorities, voices, all gathered here today. Greetings from Aotearoa, New Zealand. Thank you so much for the opportunity to speak to our paper, An Opportunity for Impact. This paper was drafted by Natalia, Rebecca Kingy, Quinton Lake, and I. We published it when the New Zealand government opened for consultation on a modern slavery law proposal at the end of April this year. And our purpose in drafting this paper was to present key recommendations New Zealand modern slavery law could or should encompass. The authors believe that New Zealand has a unique opportunity to design and implement a regulatory system that's set up for success, and the recommendations outlined in this paper are unique to New Zealand's geopolitical and cultural context, but they also recognise international developments. The review of the Commonwealth Modern Slavery Act was published after our report, and many of the review questions relate to recommendations we've put forward in this paper, which makes our report valid for New Zealand and Australia. And we're pleased to see that this has been of use to some of our Australian colleagues. Now, 6 months on from writing the report, we still stand by the recommendations we've put forward and still think that these should form the basis of New Zealand law. I want to thank Dame Sara Thornton for her engagement with our paper and for her comments. One of our recommendations is that an independent anti-slavery commissioner is needed, and it's clear that Dame Sara has played such an integral role in the context of the UK. It's fantastic to see her endorsement of the development of this law in other jurisdictions. This evening I'm going to outline some of the key recommendations we've set out to form the basis of modern slavery law in New Zealand. But first I'll give a little overview of the current legislative landscape in New Zealand with regard to addressing modern slavery, and an overview of key events that have led to a draft law currently being underway. I'm going to speak to features of the proposed law that are different from other similar modern slavery legislation and address what some of the sticking points are in terms of the recommendations made in the report with regard to the current political landscape. If you can go to slide 2, please. So why is modern slavery legislation needed in New Zealand? It's because there's a current gap in New Zealand's legislative landscape. New Zealand does not currently regulate broader operations and supply chain practices that contribute to exploitation and modern slavery. Despite this, we know that modern slavery is taking place in New Zealand, as it is everywhere in the world, as Dame Sara pointed out. A World Vision report on risky goods showed that $3.1 billion of imports associated with child labour and forced labour were brought into New Zealand in 2019, amounting to 5% of all of New Zealand's imports. New Zealand also has cases of human trafficking and slavery in our horticulture industry, involving seasonal migrant workers. New Zealand has a worker exploitation problem, with exploitation often nearing the definition of human trafficking and slavery taking place in a lot of our industries, including hospitality, retail, fishing, forestry, horticulture, international students. Some of our larger New Zealand companies report to the UK and Commonwealth Modern Slavery Acts, but New Zealand also has a unique makeup of companies, with 97% of our companies being small to medium-sized enterprises that employ around 30% of New Zealanders and generate 28% of our GDP. In terms of the UNGPs, the New Zealand government has committed to carrying out a national action plan on business and human rights, but made no real progress on this. I think it's fair to say that many New Zealand companies are behind the rest of the world when it comes to embedding a human rights perspective that goes beyond mere compliance with the law. And so while there's been some progress in recent years with the government using public procurement as a tool to encourage New Zealand business to respect human rights, most companies don't have a strong understanding of their supply chains and an understanding of how to address modern slavery and human rights within this. And this is why modern slavery legislation is so important. Through regulating expectations for addressing and mitigating modern slavery in supply chains, it will in turn assist companies to carry out this practice. Slide 3. Our report sets out a timeline of key events in Aotearoa relating to regulating modern slavery in supply chains at page 7. You'll see it's been a busy few years in New Zealand, and there's a natural momentum taking place for this legislation. I'll briefly outline some of the key events in slide 4. In March 2021, the government released the New Zealand Plan of Action against forced labour, people trafficking and slavery. This said that the government would consider legislation requiring business to report publicly on transparency in supply chains to help eliminate practices of human trafficking. On the same day, an open letter signed by over 100 New Zealand companies was presented to the government, and it asked the minister to commence an inquiry into a Modern Slavery Act for New Zealand business and public sector supply chains. In June 2021, a public petition signed by 37,000 New Zealanders was presented to Parliament, asking the government to introduce modern slavery legislation. You can see that civil society has had a large impact on on requesting this law from the onset. In March 2022, the Petitions Committee report urged the government to bring legislation addressing modern slavery before the House as soon as possible, while allowing for adequate policy development and public consideration. In April 2022, the government launched a public consultation on proposals for modern slavery and worker exploitation law in New Zealand. Slide 5. So a summary of feedback from the consultation was published in October, and you can read this online. I won't go into this, only to emphasise a few pretty interesting points. We had 5,625 submissions received throughout the consultation process. I think this shows really good engagement from New Zealanders for modern slavery law. In summary, there was strong support. Around 90% of people, of submitters, endorsed the proposed legislation objectives and graduated approach, whereby all New Zealand entities, including not-for-profits, the public sector, would have responsibilities to take reasonable and proportionate action to address modern slavery. I guess a key point here is that this law would apply to small, medium and large businesses, which is a point of difference as well. Submitters were supportive of the revenue thresholds set out, with a large company defined as $50 million New Zealand dollars and medium $20 million. This is significantly lower than the UK and Commonwealth financial thresholds, and this equates to around UK 25 million pounds and Australian dollars 46 million for large companies. Submitters were generally happy with worker exploitation being included in the law, and this is another very key point of difference to the Australian and UK law. The New Zealand law proposes that worker exploitation should be addressed in domestic supply chains, whereas the other acts have a focus on modern slavery, the slavery definitions. Submitters also generally supported robust due diligence protocols. The proposal outlined that a graduated approach to due diligence would take place with large companies and small and medium companies that are parent holding companies or have significant contractual control carrying out due diligence. Many submitters agreed that non-compliance should be penalised proportionately to a company's size, and they supported an independent oversight mechanism, a central register, and comprehensive support and guidance to accompany any law. Slide 6. So where are we up to now? A draft law is underway, and we're hoping that this may be presented to the House of Representatives by the end of the year. I think it's fair to say that the draft law is fairly progressive and has had input from the Modern Slavery Leadership Advisory Group. So there's been a very robust process in terms of strong expertise feeding into the modern slavery law proposals for New Zealand, and there's been a lot of engagement with business and with civil society. New Zealand has an election coming up in September 2023, and it does feel like there's a lot of momentum to get this law over the line before then, especially because so much great work has taken place under this government, and it's unclear what a change of government would mean for this legislation. The opposition National Party released a private member's bill for a Modern Slavery Act at the time of consultation in April of this year. It was very similar to the Commonwealth Modern Slavery Act before its review, so very similar to the Act before these potential proposals and reviews have been set out. And it presented a much more conservative proposal that didn't take into account global developments taking place. I guess there's a small fear that a change of government might mean that some of the progress on this law could be stagnated. If you could go to slide 7, please. I'm now going to briefly touch on 3 recommendations from our report. So the first one is that our report says that entities captured by this legislation should all entities should be captured by this legislation. So the public sector and not-for-profit, small, medium and large companies should be affected with a proportionate approach based on their risk profile. This means when looking at the level of obligations, the sector of activity, risk profile, business model, nature of operations, products and services should be considered. Slide 8, transparency. We outlined that transparency in supply chains should be a key feature of New Zealand modern slavery law. This is where the risk of modern slavery in supply chain is identified and publicly disclosed. Transparency and disclosure is really important because it raises awareness of modern slavery and provides information to the public and the market, including investors, that can assist with business engagement. It also assists in showing improvements in a company's practice that can be measured over time. Obviously, transparency is a prerequisite to human rights due diligence. However, alone, transparency and disclosure, we say, is an incomplete and inadequate strategy for addressing modern slavery in supply chain because it places no onus on companies to address modern slavery, only to identify it. A recent report just published by our government outlined that in the context of New Zealand, transparency provisions are necessary but unlikely to give business and public sector organisations enough incentive to move beyond a minimum compliance approach to the issues. The report further goes on to say that enforcement, penalties and due diligence provisions may counter the weakness of transparency in supply chain provisions. Transparency in supply chain has been a really strong feature of UK and Commonwealth Acts, and we say that this needs to be a central feature of New Zealand Act, but the New Zealand Act needs to go further. Slide 9, mandatory human rights and environmental due diligence. I know Natalia is very keen to speak to this as well, so I'll just make a few comments here. Our report outlines that mandatory human rights and environmental due diligence should be followed, focusing on both human rights and environmental risks. We did have some feedback from some of our peer reviewers that said that we should potentially leave out the environmental aspect as it's too wide of an ask and would most probably not be considered by the government. And we accept this and note that environmental due diligence is not within the ambit of the current government proposals. However, we were keen to propose what New Zealand's model law should look like. And if there was more time, if there was more opportunity for policy coherence amongst all of New Zealand laws, then mandatory human rights and environmental due diligence is what we should be aiming for. It has a much larger scope of application than modern slavery legislation because it encompasses the regulation of modern slavery specific practices as well as protection from violations of other human rights and environmental norms. And in making this recommendation, we were looking at proposals in the EU. We were thinking about policy coherence with overseas regulations and the potential issue of New Zealand companies having to report to a number of regulations that set out different expectations, which could potentially be problematic and burdensome. And we were also looking at the unique context of Aotearoa New Zealand, which has a very strong culture of addressing sustainability and environmental impacts. So as I've noted earlier, while New Zealand may be behind in addressing human rights through supply chains and through corporate practices, New Zealand entities are ahead in terms of addressing the environment. In fact, we've already started legislating mandatory environmental due diligence through a recent law, the Financial Sector Climate-Related Disclosures and Other Matters Act, which assists the financial sector to meet obligations to achieve carbon neutrality by 2050. We predict there'll be more mandatory environmental due diligence to come for New Zealand, so we thought it made sense to put this together with mandatory human rights due diligence in the context of modern slavery because these are complementary. In terms of human rights due diligence, we think that this should be in accordance with the UNGP, so that entities have to identify, prevent, mitigate and account for how they address human rights in global and domestic supply chains. Recent research from Australia shows that companies are not doing human rights due diligence well, with 40% of companies assessed being non-compliant. This indicates that a more prescriptive approach to human rights due diligence may be required in law with accompanying guidance. I think it's important to note that responsibilities to identify, prevent, mitigate for, and account for addressing human rights in supply chains generally relate to concepts such as meaningful and direct stakeholder engagement, collaboration with other entities that have similar supply chains, strategic decision-making at board level being normalised for modern slavery, and providing workers to be part of providing solutions for identification and mitigation. As outlined earlier, it looks like New Zealand's modern slavery law proposal will put an onus on large companies and parent companies with contractual control to carry out human rights due diligence of their supply chains, and we do support this. That is my little summary of 3 key points. We could go into every point, but I'll turn over to Natalia now. She's going to continue and speak to some more of our recommendations. Thank you.
Thank you, Rebecca, for this rich statement and interesting proposals, bearing witness to your experience in research, advocacy, and action on behalf of victims of modern slavery. And now, Professor Natalia Zablewska, looking forward to listening to you from Great Britain. You have the floor, please.
Thank you so much. Once again, thank you very much for the invitation. I'm delighted to be able to provide my commentary on the theme of today's seminar along Sara and Rebecca, and more specifically on the recent developments in this space in Aotearoa, New Zealand. And I really will be building on what Rebecca has said, and to some extent also to what Sara has said, in the sense that as Michel has already mentioned, I'm based in the UK, but due to my work with Australian Lawyers for Human Rights in Australia and also with the advisory group in New Zealand, I'm going to be building on my experiences of working in both jurisdictions. And as Rebecca has very rightly pointed out, there are lots of similarities but also differences. And that's been the case globally in the sense that each and every jurisdiction builds on the lessons learned by the previous jurisdiction. And so one other point of difference I think is worth emphasizing in relation to the current developments in New Zealand is that the legislation, the proposed legislation is very much based on and is values driven, which is something that is quite unique to the New Zealand context as well. Now, before I go into the details of the proposals, the remaining proposals of our report, and also provide a bit more context of what's happening currently in New Zealand in this space, I just wanted to point out that the timing of this webinar is also very relevant, as it coincides with the 11th UN Forum on Business and Human Rights that opened on Monday, and with the guiding theme on rights holders at the center, strengthening accountability to advance business respect for people and planet in the next decade. So I think it's one of the many initiatives and events that have been happening in recent years. It really helps to further elevate human rights in the context of business, and as part of, if I can say, normalizing business practices that take into account human rights. It also highlights the links between business and human rights and environmental concerns. And although these are and should be seen as going hand in hand, we know that in reality that doesn't necessarily often happens. Some of the audience might have been following recent news that links the extensive forced labor and slavery in renewables supply chain. So this is, of course, hugely problematic, as on the one hand, lots have been invested, and rightly so, into more sustainable means of producing energy and tackling climate change. On the other hand, and because of current business models, including supply chains or value chains, it means those attempts often perpetuate inequality and exploitative practices. And whether that is in relation to production of polysilicon, which is used for solar panels, and we know that half of the world global production of polysilicon comes from China, and the abuses of Uyghur people and Kazakh people in the Xinjiang region in northwest China being exposed now on a number of occasions, or whether we're talking about mining of cobalt, which is essential for development of batteries in places such as the Democratic Republic of the Congo, where we know that children, often as young as 7, are routinely used as laborers. There could be other examples. So very rightly, the newly appointed, or shall I say recently, relatively newly appointed New South Wales Anti-Slavery Commissioner, Dr. James Cohane, that really what we need is urgent action. Otherwise, modern slavery risk will significantly complicate the just transition to decarbonized economy. So it will really affect whether and at what cost we can deliver on the promise of sustainable future for all, which is the underlying aim behind the 2030 Agenda for Sustainable Development. And so once again, going back to what I said earlier, the 11th Forum on Business and Human Rights, it really touches on a lot of those aspects, the linkages between human exploitation, but also environmental degradation, something that Rebecca already highlighted. So zooming back onto New Zealand, Rebecca has already provided the statistics. We know that modern slavery and different forms of modern slavery affect everyone globally. So this is not, in that sense, there is no region of the world, or country, jurisdiction that is free from either directly or indirectly through the supply chains and the use of global supply chains. But focusing on exploitation of migrant workers, which is a specific and issue that's been looked into both by the government and a number of studies have been produced to show that migrant workers are a particularly vulnerable group along with international students in New Zealand. Now, in the recent times, in addition to the current legislation that has been currently proposed, there have been developments, legal developments, and further resources have been provided by the government as well. Last year, the government designated additional 50 million New Zealand dollars in funding to combat exploitation, alongside changes to the law, including creating emergency visa so migrants could leave their employers in a lawful manner. There's been also a hotline that has been set up for workers who need help. More recently, there has been introduction of an accredited employer work visa, which basically requires employers who want to hire migrant workers to go through certain checks before they can do so. This is important in a country where majority of some of the industries that Rebecca has already mentioned that have high risk modern slavery, predominant workers are migrant and short-term workers, predominantly from the Pacific. Now, all of these are important developments. However, people, in particular migrant workers, I've already mentioned, continue to be exploited by unscrupulous employees and employment agents. So the practicalities of it need to be taken into consideration as well. So you might ask, why do we have those positive developments, but at the same time, they don't seem to necessarily directly or at least mitigate some of the aspects of modern slavery in New Zealand, but not completely. Now, going back to the example I've just given of the accredited employer worker visa, what needs to be understood in the from a practical point of view, that the ministry that is responsible for those checks, the Ministry of Business, Innovation and Employment, MBE for short, they have funding for some checks, but not all of them. So what it means is the government accreditation is often based on paper. So what the employers provide and tell the government that they're doing, and in terms of what they attempt to do in order to have the permission to employ and hire migrant workers. So in many ways, it is still possible for employers to get around such paper-based accreditation and unfortunately continue to exploit vulnerable workers. One of the issues that have been raised on a number of occasions in New Zealand, but also in other countries that have similar provisions in place, is tying employment or visas with employment, because it's always going to create an environment conducive for abuse, simply because it creates significant power imbalance between the employer and the employee. The response of the government usually in favor of those arrangements, and that's been the case in New Zealand as well, is that it's necessary for migrant workers to be employed in specific areas to support the country's economy. However, that should never be done at the expense of the most vulnerable in the society. So really what we need is a much more robust system that requires more transparency, disclosure. We already discussed that, oversight and accountability, and that also includes remediation for harms caused. So this is the reason why our report focuses so strongly on victim-centered or rights-based approach to regulating modern slavery. And remediation mechanisms have been mentioned both by Rebecca and Sara as very important, because despite the fact that this has been already agreed that this is a good practice, and that's also in keeping with the United Nations guiding principles on business and human rights, UNGPs, not many acts, not many legislative acts actually provide for access to justice to victims. And just to clarify, I use the term victims as a legal term, not in any way to value the agency of survivors of modern slavery. So when we're talking about labor exploitation, workers should not need to rely exclusively on voluntary remediation processes offered by businesses. And then we have those in place, they can work, but we know it's not sufficient. So in that sense, that's the reason why we have advocated for very strong and specific calls of action for workers subjected to modern slavery to seek redress. And when we talk about redress, we're both talking about compensation as well as other forms of support in the event that the entity might have failed or did fail to exercise a due diligence to prevent modern slavery, both in their operations and supply chains. There have been calls made globally now for compensation funds to provide an appropriate remedy to people subjected to exploitation by companies, either through the operations or supply chains. And the benefits and the urgency of such a scheme, they have been already raised on a number of occasions, including in Australia with Anti-Slavery Australia. So this is definitely something that has been discussed in New Zealand as well, and definitely needs to be further considered, not only in New Zealand, but much more widely. Because ultimately, when we're talking about migrant workers or exploited workers, raising awareness of their rights is critical, but not sufficient on its own. What we really need is a system in place that supports vulnerable workers, including their ability to make claims for abuse and if they experience abuse and exploitation, as well as shifting the burden of proof onto the company to show that they have complied with the law. And there are a number of reasons for it, including the access to evidence and data is often limited, if not impossible, for many of the people who have suffered from modern slavery. So this is only right. That is, the burden is on the companies to show that they have complied and that they have done reasonable due diligence. On a number of occasions, we've already mentioned Anti-Slavery Commission and the need for it. I don't think that that is particularly controversial issue in a sense. It's been widely accepted that this is a key feature for any anti-modern slavery legislation. And obviously, when we say Anti-Slavery Commission, what we mean by it is a well-resourced and independent regulator, whether that office is called Anti-Slavery Commission or something else, that is really irrelevant for the conversation. But it really needs to be free from and not subject to the control or direction of any government agencies in the exercise of its function. Something also that Sara has mentioned from her own experience, the length of time there in office is important, because that really allows the commissioner to take action and to make a difference to the victims of modern slavery. Under this, the current review, statutory review of the Modern Slavery Act in Australia, the Commonwealth one that Rebecca has already mentioned, the government itself suggested a number of functions for such anti-slavery commissioner, because there is none at the moment at the Commonwealth level, the federal level, but there is anti-slavery commissioner under the New South Wales regime. So obviously, within this short period of time, it's been quite clear that there is significant benefit to having anti-slavery commissioner to ensure that could range from examining whether entities complying with the requirements of the legislation, even to recommend imposition of penalties or helping with the conduct of periodic reviews, etc., etc. So I cannot imagine that we could have an effective system in New Zealand without having an Office of Anti-Slavery Commissioner for the very reason. An advisory group is part of that package because it really is our auxiliary role is to provide expertise on the specific areas to the government to ensure that it's up to that the act, once implemented, is really responsive to the emerging issues both in New Zealand and internationally. And obviously the group itself should comprise of those with specific but also complementary expertise and be representative of all the stakeholders within the society, including the most vulnerable, such as workers themselves. Now, penalties, it has been and it's going to continue to be a controversial matter. And for various reasons, though, we have now had many more, if you like, more open conversation about penalties. That penalties are really necessary part of the next step, if you like, or for us to be able to ensure compliance with whatever the obligations might be. And when we're talking about penalties, they could range from those convicted of migrant exploitation, for example, being put on a public register. We could be disqualified from managing or directing our company. We could be talking about financial penalties, etc., etc. Now, one of the criticism against penalties, and obviously, understandably, businesses are to some extent, I'm not necessarily always and fully, but to some extent reluctant to have penalties introduced. But one of the criticism is that there is no conclusive evidence that actually tougher penalties will stop exploitation from happening in the first place, and that is true. But what we also know, Michelle, you mentioned the review in the UK. Rebecca, you also mentioned the review of the operation of Modern Slavery Act in Australia, which really shows that even when it's not, so speaking of the experience in Australia, it's not a voluntary, it's actually mandatory system. Nevertheless, there are no penalties attached, so there will be no real enforcement of it. And we know that only 27 of reviewed companies demonstrated any action to address modern slavery risks by elevating working conditions among the suppliers, or tackling the root causes of modern slavery. So that was a report led by the Human Rights Law Centre earlier this year. That was published earlier this year, and actually this month, there's been a follow-up report published, which again shows that 56% of commitments made by the companies in the first round to improve the modern slavery responses remain unfulfilled in the second round. So I think it really, what we have reached is the place where, yes, prescriptive or some form of voluntary approach is necessary, but also, and very importantly, more mandatory approach is necessary, including penalties. The final recommendation in our report is in relation to import bans, which is really, from our perspective, it is an integral part of any anti-modern slavery legislation. Because in order for businesses to undertake effective due diligence of their operations and supply chains, and that includes identifying and addressing the salient risks, it requires from the government to introduce a ban on the import of goods that we know are being produced by forced labor, wherever that might occur. There is sufficient evidence showing that this can be done and can have an impact, practical impact on the workers' life, whether that is based in the country where the ban is introduced or elsewhere in the global supply chains. Sara did mention United States, Canada, and they've been doing that as well. There have been recent conversations in Japan and some other countries along the same lines. Now, for New Zealand and Australia, the matter is highly politicized because a lot of the evidence that we have in relation to China, it's also because of geopolitical location of New Zealand and Australia. It means it might be more practically difficult to introduce some of the bans to the extent that has been done elsewhere, but obviously civil society and those who have workers' rights and anyone else's in mind will continue to advocate. Only last week, a bill to amend the Customs Act in Australia to ban import of goods made with forced labour was introduced in Australia and to Australian Senate. So I think this is definitely something that will come back again and again in perspective of the context within which it's being discussed. Now, so just to sum up, so the 10 recommendations from our report, in many ways, are those that have been followed and recommended generally on a more global level. And obviously, they need to be adjusted to the relevant context, national context, cultural context, etc. And in many ways, New Zealand is an indicator of, in that sense, where we are and the direction we are heading. So, taking into consideration developments in New Zealand, because I do want to finish on a positive note there, as well as globally, I think we really have reached the necessary political momentum to bring about the necessary change. Simply by looking at the number of legislative reforms and changes that have been introduced in recent years, and also those who have been looking to developing or in the process of developing such legislation, New Zealand being one of them, Netherlands is another one, but also South Korea, as well as Colombia, where there have been interesting developments, because in Colombia the focus has been very much both on human rights and the climate change, so very strong on social environmental practice in that respect, which is very, very encouraging. And I think we're going to see more of it in due course. As Sara did mention in the foreword to our report, legislation is not a silver bullet. So putting differently, law, it's not sufficient on its own, because what we need is a wider cultural change, which obviously is and can be instigated and encouraged by those legislative changes. But we really need a significant change the business model we currently have. So on that point, and I'm going back to supply chains, because for entities and especially private sector to regulate their own operations is somewhat easier than within the supply chains, than their supply chains. But nevertheless, aligning supply chain processes with relevant legislation, anti-modern slavery legislation, encourages structural change. Otherwise, it simply becomes an information provision exercise, which is devoid of adequate solutions that can provide for any options for preventing as well as remedying modern slavery when it occurs. So to answer the question in the title of our seminar today, yes, we definitely need to encourage the mix of approaches with voluntary, prescriptive, and mandatory, both national, regional, and international level, that will provide us with most likelihood of success in mitigating and preventing modern slavery wherever it occurs. Thank you.
Thank you very much, Natalia, for sharing us your experience and academic expertise. I must say, I would have two questions, and possibly would be happy to hear again Rebecca on this. And those two questions would be, first, what are the chances of success of your recommendations in New Zealand and in other countries? And the second question, How do you see the role of consumers? You see, I don't know. May I ask Rebecca to say a word about this, and then back to Natalia?
Sure. I think a lot of the recommendations that we've put forward in our proposal are being taken into consideration in the current proposal that's being drafted in New Zealand, particularly around entities, penalties, anti-slavery commission or independent oversight mechanism, and the due diligence requirements for larger companies. Transparency in supply chain, I think a lot of these key points have been taken into consideration, or at least are being quite rigorously debated in the context of New Zealand as this proposal for law is being drafted. So I think the issues that we've raised in our report are issues that the whole world is grappling with. You know, what entities should a Modern Slavery Act apply to? What should a financial threshold look like? What does proportionate? How should Modern Slavery Act apply proportionately? Should risk to sector and business be a consideration? These are key points that we've seen in the Australian review and in New Zealand, and I would say that a lot of the key points that we've put forward probably will be seen in New Zealand's legislation when it's finalised. One of the key points that we've raised that won't be is the human rights and environmental due diligence, because environment is not being considered in this particular law, but that's okay, because this law has a real focus on modern slavery, and we might see in years to come amendments to acts potentially as we understand more whether human rights due diligence is as effective as we think it might be. As Dame Sara Thornton outlined, and other academics have outlined as well, there is not a lot of research yet showing whether human rights due diligence is incredibly successful, and that information will come in years to come, I think, and we'll be looking for it readily. Natalia, would you like to follow?
Definitely. Thank you so much, Rebecca. Yeah, I completely agree with Rebecca on that point, because law is not static. And so that's why it's so important that it's not only that we have legislation passed at domestic level, but also we have a review of that legislation. So it remains current. That's been the case at the Australian level. So as I said, in the Commonwealth, just to compare with the New South Wales regime, initially, the threshold was much lower, half of what the Commonwealth is currently prescribing. Also, anti-modern slavery commissioner is part of the New South Wales legislation, which is not part of the Commonwealth legislation, as well as initially penalties were prescribed under New South Wales legislation. That had been unfortunately amended, but the conversations about what can we learn from the other practices and how can we improve on the current legislation are very, very alive in Australia. And I would be very, very surprised if we didn't see an introduction of anti-slavery commission at the federal level. I'm really hoping for some form of enforcement through penalties as well. So we definitely, as I said earlier, each and every jurisdiction builds on lessons learned elsewhere. And so that also applies to within the same jurisdiction. So even though the legislation in New Zealand might not cover both human rights and environmental due diligence, but I think in time that will change. This is approach taken in, for example, in Germany, the German legislation at the EU level, the directive on environmental and human rights diligence. Very recently, also bill for responsible and sustainable international business conduct was introduced to the Dutch Senate, House of Representatives, and that covers both and aims to address human rights, environmental, and climate harms. So I think we're definitely going to see more of it, and along with it, probably in some time in the future, that conversation will reopen in New Zealand as well. Now, on the second question on the role of consumers, we do have a lot, and we can change. We can change how things are being done. Last year, through Australian Lawyers for Human Rights, we organised a webinar that very much focused on what action as individuals, but as citizens and as consumers, we can take to address modern slavery. And the reality we are facing is that most things that we buy, most things that we consume, had some footprint of modern slavery somewhere in the world. Now, what does that mean is that by our choices as consumers, we can put pressure on companies or on businesses to do the right thing. So we as consumers do have quite a bit of power to make things better and to make a change. So I definitely would encourage anyone who feels that there's it's necessary, as I said, to ensure that no one anywhere, wherever they are based in the world, is not exploited because of business practices, to pay more attention to what they buy, what they're buying from, and trying to find out the ethical stance of those businesses before they purchase from them. In these days, there are many many apps that allow us to make much more informed decisions, much more than many years ago. So it's not necessarily requiring individual consumer to go on a website and register, let's say, and read the statements of each and every company. So there are now ways for us to make the conscious decisions, what we buy, how we buy, who we're buying from. And in that way, we really do contribute to that change. Oh, I can see, Michael, your comment. Apology. Of course, I will make sure that I speak slower. Thank you. So this is the key points I would like to say in relation to those two questions. Both of them are very valid and very good questions. So thank you for whoever asked those two questions.
Mm-hmm. And Rebecca, allow me to ask you again, do you see any role for consumers to press for any of your proposals, recommendations?
Yes, actually last year there was some research done on New Zealand consumers, and New Zealanders said that knowing a business treats its workers fairly is always, or most of the time, a key factor when deciding where to shop. So 50% of consumers in New Zealand said that understanding the practices of workers informed their decisions for where they shopped. So I think consumers have a really strong role in calling for stronger practices, demanding that the products that they use and buy are free from modern slavery. And I think there's more and more research needed to show what products are associated with modern slavery and give consumers the ability to be able to put that pressure on. And I think aspects of transparency and that where people can actually see a company's performance really aid in giving consumers that buying power and decision-making capability. So, yeah, I think consumers have a large role. And in terms of New Zealand and this particular legislation, we've seen so many Kiwis, so many New Zealanders really care about this legislation through signing the petition. 37,000 people signed that and making submissions. So it's very clear to us that New Zealanders are really concerned about modern slavery and that they want a modern slavery law so that they can feel like they are making the right decisions in how they carry out their business and consuming activity.
Thank you very much. Another question: how do business companies react to your proposals? Are they willing to go along, or are they resisting? Whatever. Let me say, it would be interesting to to know more about the other side, I would say.
I was just looking at the feedback from the consultation, and 90% of submitters did say that they agreed with the proposals for modern slavery law in New Zealand, and a lot of the submissions did come from New Zealand companies. Some New Zealand companies are already reporting to the Australian and UK Act, and there's also implications when trading with the EU as well. New Zealand business, I think, is overly invested in modern slavery legislation. There was a letter signed by 100 New Zealand companies in support of this kind of legislation last year. And the 100 companies represented a lot of our large companies, but also a lot of our small to medium enterprises. And it was really representative of a very wide spectrum of business in New Zealand who are in support of this type of legislation. I think there are some key aspects of the legislation that business are wrestling with, and I think these are the things that we're discussing and debating at the moment. For example, obviously there's always concerns around the cost of implementing this kind of legislation, especially when a lot of New Zealand companies are small to medium enterprises. They might not have a large number of people working for the company, and so I think providing prescriptive guidance and tools that can assist companies to embed this kind of legislation without having to designate heaps of budget to it, making it as easy as possible, are some of the key ways that we can address business being more on board with this. But I would say overall, business are very supportive of these proposals in New Zealand, shown through that open letter and also the number of submissions that were put through from business very recently to the consultation proposal.
Yeah, so just to build on what Rebecca said, from my own experience, and this is often a misconception that businesses will resist, are going to be the ones that will have to be dragged into doing the right thing. And working with businesses directly through my work in New Zealand, in Australia, and also working with my colleagues and listening to my colleagues who work with businesses directly, majority of businesses are very accommodating, and they understand that we need a change. We cannot, same as with environmental impact, we cannot continue doing business as usual anymore. Because the planet will not be able to sustain us, and in that sense, the business model that is based on exploitation of people because they might be based overseas is no longer sustainable either. So whatever the motivations of businesses, and also things like branding and pressure from consumers, because we touched on it earlier, all of those factors mean that businesses overall are going hand in hand and really engaging in this conversation. So I think that is very positive and very encouraging. The details, this is something that obviously needs to be worked out, and again, more a practical point is that we don't really have a fix or kind of idea of how to fix the problem. If we had that model in mind and we knew that it's going to work, we would have introduced it a long time ago, right? So something that Sara has mentioned earlier, do we know, is there evidence that due diligence will work? And this is the reason why we're pushing for due diligence, the majority of us in the civil society and academia, is because there is enough evidence to show that if you just do transparency, and you often, that allows entities to engage only at the surface level with the problem. So really what due diligence allows us to do is to dig in and look, and for the companies to understand what happens, what corporate impact they have, and what happens within their supply chains. Because we also have to take into consideration historical developments. Globalization of supply chains led to lack of visibility or hence transparency of supply chains. And this is not necessarily something that has been required from companies to know. Most companies would know maybe the first tier because they would have contractual obligations, but they would have no clue what happens down the line, if you like, or further down their supply chains. So this is a learning curve for everyone. So it's not necessarily that businesses have the practices or processes in place to introduce. This is not necessarily lack of will, but a lack of capability, a lack of know-how and how to do it. And so hence Rebecca mentioned, when we're talking about small, medium enterprises, they do have less resources than some of the multinationals to engage with it. And so we need to make sure we take businesses with us rather than introduce this as against businesses. It really is about leveling playing field for everyone. And I think it's now fully understood that, as I said earlier, business as usual is no longer sustainable. And in many ways, it requires a shift in thinking, because businesses, irrespective of the size, they've always been doing business risk analysis, because otherwise we wouldn't survive as a business. What are we asking now businesses to do? That risk analysis includes human risks and potentially, in some contexts, also environmental risks. So in many ways, what is new is what are we asking the businesses to look into and look for, but not actual risk analysis, which all businesses have been doing, and this is part of and parcel of running a business these days.
Else, I could try to conclude, and if you think of any parting words or concluding statements, I would be happy to give you the floor again. But I must say, of course, modern slavery exists because there is a demand coming from individual customers and collective public procurements for goods and services that unfortunately could be met through exploited or forced labor. We consumers and shareholders must begin to see ourselves as part of the problem, but also as part of the solution, being more mindful of our choices, as well as putting pressure on governments and business to address the exploitation and human rights violations in global supply chains. We can participate in making a dent in this worldwide crime, exposing millions of workers to exploitation, abuse, and worse. And in conclusion, I would strongly encourage stakeholders, governments, and companies to implement the measures discussed in this seminar to improve supply chain transparency and reduce forced labor. In our online course, as well as in the quistusliberat.org website, you shall find a series of domestic legislation and 30 national action plans. Other websites such as legislationonline.org and antislaverylaw.ac.uk allow access to most domestic legislations and national action plans. And actually, at the end of this webinar, I would like to thank not only the speakers, but also the participants. I think we had a very intense webinar, thanks to our outstanding speakers, our best wishes for the three of you, and thanks also to the listeners and for the interesting questions we received tonight. My special gratitude also goes to Yves Reichenbach, our webmaster, and my right hand, and to my assistants in Geneva, Clara Brege-Isepi and Emanuele Piluso. I would like to invite you to our upcoming webinar next Tuesday, the 6th of December at 6 p.m. on faith and human trafficking. Excuse me. Testimonies of sisters working in the rehabilitation of victims. The video recording of this webinar shall be available in a few days on our website at laudatosi.org with subtitles in English, French, German, Italian, Russian, Spanish, and Chinese with written transcripts. Feel free to share the link. And our online course on human trafficking for helpers is now translated and available in French on the cuhd.org website. It will soon be available also in Italian and German. But now, last question to both Rebecca and Natalia. Would you like to say a few words in conclusion? Rebecca?
Thank you, Michelle. I'd just like to say a huge thank you for the invitation to speak and present our report today. A lot of time and thought went into our report, and we hope it's a resource that can be used in the EU and Australia, everywhere where modern slavery or supply chain legislation is being considered. I'd just like to thank again Dame Sara for her thoughts and her engagement with our work, and a big thank you to you, Michelle, for the incredible work that you're doing profiling work like ours, but also your mandate and everything that you are doing to further sorry, my children are upstairs being noisy. Sorry, everything that you're doing to further the development of this law and policy globally as well. Thank you very much.
No, thank you very much, Rebecca, and also my best to your husband and your family, and including your child, and best to New Zealand, of course. And now, Natalia,
Yes, thank you. Just going to echo Rebecca here. Thank you so much for the invitation. Thank you for the interest in our report, but also thank you for the interest in the developments in New Zealand, which from many perspectives might feel like a land really far, far away from everywhere else, but obviously there is lots of good, positive things to be learned from each and every corner of the world. So in that ways, we are thankful for the fact that developments in New Zealand caught your attention, and this is something that you wanted to share with the wider audience who might otherwise not necessarily be aware of those developments. On my very final point, I want to say, because Michelle, you said very rightly, the number of estimated number of modern slaves is unprecedented in terms of human history. So, and it is a global issue. No country, no region is free from effect of modern slavery, directly or otherwise. So, I would say that one of the key aspects of dealing and addressing modern slavery is collaboration and partnerships, effective partnerships, sharing of information, sharing of best practices amongst businesses themselves, but also amongst the enforcement agencies. And so we need more a global approach to modern slavery, which obviously would take into consideration the specificity of different regions and countries. But ultimately, this is a global issue, and we need a global efforts and global response to that issue. Therefore, we should avoid fragmentation and thinking that can be dealt with from within one nation or within one region. So that's all I want really to say. And once again, thank all the people who participated, asked the questions, and might be listening to this webinar. Thank you.